There is a staffing rule called the Employing Office Doctrine. It appears in no law you've read as such, and it has existed since January 23, 1995, buried inside the Congressional Accountability Act. It means all 535 members of Congress are not legally one employer. Each office is its own. No one voted on that distinction by name. It just became the architecture underneath every job on Capitol Hill. Here's what that means in plain terms. When you work for the federal government, the IRS, the VA, the Department of Labor, you fall under a unified civil service system. Job protections, pay scales, appeals processes, all standardized. Congress exempted itself from that system decades ago, and then in 1995 it went further. It didn't just opt out of civil service rules. It split itself into 535 separate legal employers, one per member's office, plus committees. Each one hires, fires, and sets pay with almost no oversight connecting them to each other. You could work 3 doors down from someone doing your exact job, for less money, with no protection, and no one would be violating anything. This didn't happen by accident. Before 1995, Congress simply wasn't covered by most workplace laws at all. No Title VII, no Americans with Disabilities Act, no Fair Labor Standards Act. That was an embarrassment lawmakers eventually couldn't ignore, so they passed the Congressional Accountability Act to look accountable. But when they wrote the enforcement mechanism, they defined the employer not as Congress, not as the House, not as the Senate, but as each individual employing office. That single definitional choice, a few lines in a statute most Americans have never opened, quietly preserved almost everything the reform was supposed to fix. No floor debate mentioned it as a loophole. No vote was cast on the phrase employing office. It was drafting language, and drafting language, once codified, has the same force as anything Congress ever shouted about. Now here's who actually controls it today. Enforcement sits with the Office of Congressional Workplace Rights, a body created by the same 1995 law, staffed and funded by Congress, answerable to Congress, with board members appointed by congressional leadership. The people who might be investigated appoint the people who investigate them. That's not corruption in the criminal sense, it's structure. It was built that way on purpose, and it has never once been ruled unconstitutional, because Congress has near total authority over its own internal operations under the Constitution's rulemaking clause. What this means for an ordinary staffer is stark. If you're fired from a congressional office for reporting harassment, for a pregnancy, for your religion, you don't sue in federal court the way most employees can. You go through the OCWR's internal process first. Mandatory counseling, then mediation, both confidential by law. Only after that closed-door sequence can you even consider litigation. And by then, most staffers have signed away detail after detail under non-disclosure terms baked into the process itself. In 2017, during the height of Me Too reporting, journalists discovered Congress had quietly paid over $17 million in settlements for workplace claims since 1997. Funds from a Treasury account, not from the individual offices where the conduct occurred. So the responsible office faced no direct cost, no line item, no consequence attached to their name. And here's the part that should actually worry you: none of this is a scandal in progress. It's completely legal. Nothing here violates a statute, because the statute is the thing that built it. There's no prosecutor who can touch it, no inspector general with jurisdiction over the design itself, because the design is the law. Remember, no one voted on the words employing office. And that's exactly why it can't be repealed the normal way. To change it, Congress would have to vote to bind itself to a unified employer standard, surrendering the discretion every single member currently holds over their own staff. Turkeys don't vote for Thanksgiving. Every reform bill introduced to fix it since 1995 has died in committee, the same committees run by the offices it would regulate. What this tells you is bigger than staffing. It means the institution writing employment law for the entire country exempted itself using the same tool, a quiet definitional clause. that it could use anywhere else. Immigration law, financial regulation, environmental rulemaking. If employing office can hide an entire workforce from federal protections for 30 years without a single named vote, the real question is how many other definitions like it are sitting inside other statutes right now, doing exactly what they were built to do.